This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why not having an alarm when it was required makes a insured have no coverage at all. Kinsale Insurance Company sought declaratory relief as Seabrook Harbor and Marine et al. Argued that Seabrook failed to comply with a condition precedent in the insurance policy it issued to Seabrook, and that consequently there was no coverage for a fire occurring at a Seabrook facility. In Kinsale versus Seabrook et al., the United States Courts of Appeal for the Fifth Circuit on March 7, 2024, explained the importance of a condition requiring protective safeguards. The policy contained what was called a protective safeguards endorsement, requiring that Seabrook maintain an automatic fire alarm protecting the entire building that is A, connected to a central station, or B, reporting to a public or private fire alarm station, close quote. The summary judgment evidence established that although Seabrook had a security theft monitoring system, it did not have a fire monitoring system. Kinsale moved for summary judgment in its favor, and the district court agreed. Seabrook contended that it had a good faith belief that the property was covered by a centrally monitored fire alarm system, which included hardwired smoke detectors. It further argued that Kinsale either waived its right to exercise the protective safeguards endorsement or should be stopped from using it to deny coverage because the absence of a centrally monitored fire alarm system did not increase the, quote, moral or physical hazard, close quote, under the policy. Specifically, Seabrook argued that, quote, a centrally monitored fire alarm would not have alerted the New Orleans Fire Department any sooner in battling this conflagration, close quote, because the fire's origin was outside of the Seabrook office building, and the wind-driven fire would have started on the office building's exterior in the same area as the alarm monitoring equipment. The district court determined that Seabrook's maintenance of a centrally monitored automatic fire alarm was a condition precedent to insurance coverage under the policy. It was undisputed that Seabrook did not satisfy the condition. It granted summary judgment in favor of Kinsale that the insurance policy it issued to Seabrook provided no coverage for the fire occurring at Seabrook's facility. Under Louisiana law, an insurance policy is a contract and is construed using the general principles for contract interpretation. The party's intent, as reflected by the words of the policy, determines the extent of coverage. If the words of the policy are clear and unambiguous, it must be enforced as written. The Fifth Circuit noted that Seabrook appears to be asserting that Kinsale had no right to deny coverage for the fire unless it proves that Seabrook misrepresented information to Kinsale with the intent to deceive. The Fifth Circuit disagreed. It stated, 1, the policy provisions at issue in this case are not ambiguous. The protective safeguards endorsement clearly provides a condition of the policy. When the words of an insurance policy are clear and unambiguous, the words must be enforced as written. The safeguards provision made clear that when the insured has not maintained an automatic fire alarm connected to a central station, the policy provides no coverage for the fire. Seabrook did not maintain such an alarm. Whether viewed as a condition of the policy or as an exclusion at the time of the fire, coverage for the fire was precluded. And 2, Kinsale is not required to prove that Seabrook misrepresented information with an intent to deceive in order to deny coverage in this case. Kinsale did not contend that Seabrook misrepresented information in its insurance application or in negotiating with Kinsale, and it does not seek to void or rescind the policy based on such misrepresentation. Instead, Kinsale argues that it is entitled to deny Seabrook's fire insurance claim because a condition precedent was not met and/or an exclusion applies. It was undisputed that Seabrook did not have a centrally monitored fire alarm at the time of the fire. As the district court found, the absence of such an alarm undoubtedly increased the physical hazard under the policy. The Fifth Circuit concluded that there can be no doubt that the lack of such an alarm increased the physical hazard of a fire spreading and causing further damage, as the lack of an alarm would result in either no notice or delayed notice to the fire responders. In my opinion, protective safeguards endorsements are not suggestions. They are conditions or warranties. As a result, failure to provide the protective safeguard required by the policy deprives the insured of coverage for a loss under the policy, even if the alarm system would have been irrelevant to the effect of the condition or the loss. Every person acquiring insurance with such a protective safeguard endorsement must comply fully with the endorsement or agree it has paid for insurance policy that provides no coverage for a loss. This video was adapted from my blog Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe there to the blog, and you'll be advised of every blog posting, usually 5, sometimes 6 a week. And you'll have access to the more than 4,700 blog postings. You can also subscribe to the videos on YouTube and on rumble.com, both of which are free. And if you subscribe or view these videos, I'd appreciate it if you click on the like button for YouTube or the thumbs up button on rumble.com. And if you're interested in obtaining further detail about insurance, insurance law, insurance claims, and insurance fraud, please consider subscribing to my Substack publication for a very small fee. Thank you for your attention.